I'm Laurie Bolton. I'm the counsel assigned to this project. I think that it's 40 years ago this summer that I took the bar exam, and my first assignment when I went to work, it was in Governor Reagan's Office of Criminal Justice Planning, was to work on what became the Federal Privacy Act of 1974. I spent probably the first half of my career working on enacting a lot and writing a lot of these privacy laws that I realize in retrospect have caused a lot of the problems we're facing now. So I think it's maybe a little bit of guilt that has me thinking, gosh, maybe we need to clean up some of the mess we made. The privacy laws are certainly important. When I got out of law school in '73, Richard Nixon was president. A year later, I was working in Governor Reagan's Office of Criminal Justice Planning. Soon, Richard Nixon wasn't president. We were enacting all kinds of privacy laws, and 6 months after that, I was working in Governor Jerry Brown's Office of Criminal Justice Planning. So the New York folks talked about a change in leadership. There were a lot of things going on at once at that time. Since then, starting in '74, there have been a lot of privacy laws enacted. A lot of it was in reaction to what had gone on with Watergate, which wasn't just a burglary. There were a lot of fairly egregious confidentiality violations that were going on at the same time. Unfortunately, though, over the years, both in Congress and in the state legislature, the confidentiality laws weren't particularly all well thought out in terms of how the different programs could work together. We have completely separate laws, rules for what was food stamps, what was AFDC, both of which those programs at the federal level have been changed and repealed. And yet, I remember working in the '70s on enacting Welfare Institutions Code 10850, our main welfare confidentiality statute. And those food stamp and AFDC rules are still in our state law because that's where we put them 40 years ago. We need to really be rethinking our whole approach and looking at making potentially widespread changes to make the laws more consistent so that the programs can operate better. A year ago, went to one of Daniel Stein's Steward of Change, one of their seminars with one of my bosses, Shel Culp from OSI, and we left, and it was clear that Shel had become a real convert and was interested in this topic. And then a few months later, Jerry Scribner, the chief counsel of the Health and Human Services Agency, attended a session that Daniel put on with Shel and I, and he left a convert as well. So I've been fortunate to have a couple of my bosses that think this is an important thing to work on. And so as a result, we've been at the last seminar in May, the symposium rather. At the end, we took sign-ups to work on the different areas. I ended up getting the legal confidentiality panel, and I was surprised. I expected a few sign-ups. We had 16 folks sign up. And in the next several months, we put together a team. Let's see, hold on, I got a figure. It worked. We had a meeting, and I anticipated maybe half of the 16 would show up, and there were 20 people there. That's only the first half. There's the second half of the team. We ended up with ultimately, I think, 47 attorneys from around the state, federal, county, and state level, who at least participated during part of our teleconferences and meetings, et cetera. This was a bit unprecedented and kind of shocking to me that people were that interested. I think it was also a significant thing that we had the general counsel from Region 9 of HHS, we had county counsels, a couple of whom are here today, and eventually all of the chief counsels from the departments within the State Health and Human Services Agency participating to one extent or another. So I want to thank all the folks on that screen. Hey, I did it back. Okay, who participated? What we tried to do was approach the problem from the perspective that we would look at the confidentiality statutes, examine them, and then determine what the problems were, barriers to information sharing, and then look at short, medium, and long-term solutions to the problems. Oh, I haven't seen all these graphics. Good job, Glenn. By the way, thanks to Glenn Freitas for helping out on this committee. He's done a tremendous job helping the legal folks and putting the presentation together. What we tried to do there was develop a comprehensive strategy for moving the Health and Human Services state and county departments to data and information sharing by first identifying solutions to the challenges. Identifying the challenges is something that it's important that we remember. In California, we have a state supervised but county administered program. The great bulk of the staff doing the work under the Health and Human Services Agency are county employees, which is why I have these gentlemen here, and we had a good number of county councils helping us on this project. They're on the front lines, and that's where the people find the problems and the barriers to information sharing. New York referred to the changes to FERPA last year. It was from Jim and from Judge Nash in Los Angeles that I found out that the largest school district in the state, I won't name it, but it was in a large urban Southern California county, decided that even though everyone in the country was sharing information on children's educational records with the child social worker in the foster care, that suddenly that was a FERPA violation. And they made it very difficult for LA to get information on the children. And when you've got responsibility for a child's life, and these kids are in long-term foster care for years, but you can't find out if the kid's playing hooky or flunking out, it makes it a bit difficult. We tried to work with the federal attorneys, didn't have a great deal of luck, and unfortunately Congresswoman Bass from California stood up, and she's been a long-time advocate for foster care issues and member of the Blue Ribbon Commission on Foster Care. She put through, with Michelle Bachmann, who was a foster mother, put through legislation which clarified the issue, which is I think probably the first of a number of bills that will end up coming out of this effort nationwide. So I think that what we did was look at the solutions to the challenges, plan for implementing electronic record sharing, and we had an overriding concern that we wanted to make sure throughout this that we were protecting the privacy and the confidentiality of the clients. The committee had 3 lengthy meetings, and we assigned out assessment tools to the different departments as well to assess and overcome the legal barriers to sharing, exchanging data, information, and the administration of the programs. We wanted to make sure that we coordinated with the other committees, the governance, IT, and change management. And again, we had 3 meetings of the group. What's that little picture? Oh, the puzzle, yes, putting it together. Thanks, Glenn. The systematic evaluation of barriers to data sharing between the departments. Health and Human Services has 12 main departments: public health, social services, healthcare services, mental health, drug, alcohol, aging, rehab, HIPAA implementation. I'm not going to get all of them. But at any rate, within each of the department, we set up a survey tool whereby the chief counsel and the legal office worked with the program folks and the technology folks within each department to determine what the barriers were to information sharing. They looked both at areas where they wanted to share with other departments and felt that they couldn't, or vice versa, where they wanted to get from other departments and could not. And then we've had a number of these issues raised from the counties as well. There were a good number of county councils participating, and they're not shy about letting us know what they wanted to get from child support that they couldn't get, or from even departments outside of our agency, employment development or whatever. And so they brought those to our attention. We're attempting to have those issues resolved at the departmental level between the departments, not necessarily escalating everything to this new governance structure that we talked about. As an example, we have an issue right now with the Department of Aging and inability to share information regarding complaints when their ombudsmen are out in elderly facilities with the entities that license the elderly facilities, public health and social services. So we've got the public health chief counsel working with the DSS chief counsel, social services, and the aging chief counsel to try to find a solution to this on their own. And ideally, that's how it'll be handled. If it doesn't get handled that way, though, we're setting up a structure to elevating it and bringing it into the process that Gretchen talked about yesterday. We're asking the departments to look at things in terms of next steps for both short, medium, and long-term solutions. The first 6 months, we're looking at the initial surveys, and some of them are well along. I'm not going to say all the departments have put as much in the way of resources into it as some of the others, but all of them have started a process, and they will be. This will be ongoing, as I said, with Jerry Scribner's oversight. We're going to have the chief counsels kind of try to coordinate this with the technology and program folks. We're asking that they identify when they raise issues what's the programmatic impact of denying. For example, in foster care, not sharing educational information with either the foster parents or the social worker was a clear negative impact on the foster care program and on the children themselves. So often in the child welfare system, we find that particularly when there's a bad outcome, a dead child, a severely injured child, or whatever, when the grand jury or whoever, a state auditor, comes along and audits the program and what happened in that particular case, invariably the folks look at it afterward and say, well, if we had known that information that was in the file elsewhere that hadn't been highlighted, we would have never done X, Y, or Z. And unfortunately, the outcomes are so serious that people are realizing that rather than having more dead kids, we need to find ways to make sure that the decision makers have the information that they need, whether it be judges approving psychotropic meds or making a decision to put a child back with a birth parent or into foster care, where there's information in the file that would indicate that might be a bad decision. We are trying to work things out, as I said, at the state level, and if that can't get worked out, there's a process for escalation, and if need be, recommended different kinds of solutions, including statutory or regulatory changes. We're looking at the first 6 months and then 2 year for longer term. We're asking folks to try to categorize the problems and put them into 4 different categories. First, those that state policy or regulation change will be adequate. Sometimes it's just the state agency and the attorneys involved need to rethink their legal interpretation and try to approach it from the perspective that maybe privacy is important, but maybe it's also in the interests of the client to share information. And if you can do it in a way that doesn't violate privacy or cause problems, then that might be the way to go. There are times when we may need state legislative changes. As I said, the confidentiality statutes that I worked on 30-some years ago that are based on federal programs that have been repealed are our prime target for re-examining and trying to update those. Areas where we can get the federal government to change their interpretation. There's a significant effort going on at the federal level to look at interoperability as well. This grant that Shell and others were able to get for the department is, I think there's 7 states that are doing this kind of project nationwide. And then at the extreme, there will be areas where we're going to need a federal law change, things like what happened with FERPA. But again, we have advocates in Congress like Congresswoman Bass who are going to be there hopefully to help us out in these kinds of areas. Hold on. Okay. What we're doing is working with stakeholders to establish protocols for data information sharing, and we're going to have formal agreements with the counties. An example, we worked out earlier this year, a number of the counties were having problems and concerns about their HIPAA data sharing agreements, and through the leadership at the agency with Jerry Scribner, Doug Press, Pat Pechtel at Healthcare Services, and Cal Office of HIPAA Implementation, we were able to get together, sit down with a group of the county councils, and come up with a solution that was agreeable to everyone. So we're hoping to have written agreements. We want to, in some cases, engage clients to ensure appropriate consents. Although, like New York, I think we're trying to find ways to do it without getting consents, but rather interpret the laws in ways that we hopefully wouldn't need that. and again, initiate statutory or regulatory changes as need be. In terms of the goals, privacy is important. We want to protect it. It's particularly the kinds of information we have in the Health and Human Services. When you've got child abuse investigations, healthcare information, things that couldn't get more personal. So that's important. We want to try at the state level to have uniform interpretations of law and policy so we have consistency around the state. We're trying to be transparent and inclusive in this process. We've set up an advisory group of attorneys, county councils, including a couple of the different advocate groups as well, to advise us so that as we make decisions, we're not making them in a vacuum. The goal is to serve clients more efficiently. Hopefully there'll be cost savings rather than increased costs. And at the bottom we have, I'm always a little uncomfortable with this. We're saying get to yes, and I feel like, well, it's yes, but, because as an attorney, it's not black and white. It's not either it's confidential or it's public. As an example, we issue, do we share HIV status with foster parents? Believe it or not, that was an issue in the early days of AIDS. We initially, California decided to share. New York at that time did not share with foster parents because they thought it was a confidentiality violation. Eventually, New York came to see the light and came over to the California side. But when we release that information to the foster parents, it's not public. Clearly, they need to know the child's HIV status, but they cannot share that with others other than healthcare providers or folks that have a real need to know. When you write the note for why Johnny wasn't at school that day, you can say he had the chicken pox or the measles, but you can't say he was having his HIV treatment. These are not all going to be easy black and white questions. Designing systems with interoperability is going to make them somewhat more complex, but in the long run, it will make them operate more efficiently and to the benefit of the clients, and again, hopefully result in cost savings as well. I asked Jim Owens. Jim supervises about 110 attorneys down in LA that work in child welfare.
I got the good news today. I'm up to 115. All I got to do is figure out who 115 is.
Oh boy.
And to disconnect things with the smaller counties, I got to find 115 that's Lancaster friendly.
Because
I have like,
can you all hear? Is the mic picking up?
I'm sorry, I got a number 115 has to be Lancaster friendly because I have a assignment that's about 110 or 15 miles from the main courthouse, and to staff it is always a nightmare, notwithstanding the generous bonus we give them for driving all that way. So we have a very, very small rural operation and one humongous city one.
If you guys could give some examples of the kinds of barriers to information.
I am unique because I have both the role of seeking information to help prove our child abuse and neglect cases, and I am also run the record retrieval operation for juvenile case files in Los Angeles to the extent that they come through DCFS, because we've taken it pretty much over in county counsel's office, and we do who gets access to the juvenile case records. So we see this from both ends of the spectrum. And our basic principle, which is boldly stated, is if they're entitled to our records, we want to make sure that they get the records they're entitled to. And the most common requester is the former foster youth that wants access to their files, and we do everything. We used to play this game where if they didn't get the form exactly right, they got basically a form letter denying their access to records. And we made it the mission of the people that seek the records to get the records quickly and to help whether it's the public defender, the district attorney, another county from somewhere around the state, a social worker, or the foster youth, or the foster parent, or a natural parent, we actually help them get the records. So I'm pretty proud that we've improved that. On the flip side, we're also trying to get records, and at times that can be frustrating. I'm going to give you like one example. He talks about these confidentiality laws, but they were written by different sponsors at different times with different agendas, and some with a lot of knowledge and some with not so much knowledge. And I can give you an example. One of the things that we try to do is we try to make child custody decisions based on all the information, good, bad, or whatever. If we have it and it's a probate judge wanting to make an order on guardianship, we want them to have all the information to make the best decision. Well, the way that the 827 shakes out with the access for the probate judge is he can have access and now copies of records involving the child. Of course, the guardian has not really been involved with that child. They're seeking guardianship of that child, and if they abuse their own child, that's confidential and requires a motion in court. And we think that, that it's head-scratchingly crazy. And we just want so much for it to work, and we try our best. But oftentimes in LA, when you ask somebody to go to court and get something, it's like saying no. It's not like, it's delayed. It's like no, because going to court and getting something from our court in terms of an 827 petition can take months. It can take longer than months, and it's just like, and the end result is the decision's made with less information and perhaps is not as good. Now, we have, I've looked on my little computer, we have 4 courts in Los Angeles today that will have 35 or more cases. Do the math. 10 minutes per case is 350 minutes. There's never a judge that's ever been born that sits for 6 hours on the bench during a day. They've in and out. And so the reality is that the cases go very quickly, and the people don't have time to do one extra document. We'd like to improve efficiencies. I brought one of our supervisors up here, Randy Harris. Randy designed our SNAP system. It is perhaps the most incredible thing, in addition to telling me how many cases I have each day in court. It does notices for social workers. It is streamlined everything. He's one of the actual people that has made systems with inconsistent data communicate with one another. And I'm going to turn it to Randy and let him talk for a bit.
SNAP is not food stamps.
No, SNAP is not food stamps. It's a simple notice application program, right?
And by the way, our name preceded the food stamp program name. I'm just saying. And sorry, Cecilia, I wasn't going to talk about this because I know that this gives you, nightmares. So in 1999, we started down the road of trying to make different systems communicate with each other. We had a challenge of CWS CMS not communicating with the courts database, and the courts database not communicating with CWS CMS. Not for any real great, particularly sophisticated technical reason, but we can all imagine that perhaps there are political issues behind that battle. So the problem was, how do we as county council position ourselves so that we can get data from all of the sides to put it together in some form of meaningful way, protecting confidentiality, keeping it safe and secure. So we developed this notice program, and our journey really started with a very simple question, with a then DCFS director saying, well, it's great that this system will give legal advice to the social workers, but how about printing out the forms? Can it print out the forms too? Okay, so 8 years later, we started to have some data that we can actually use. System's been in operation since 2008. It now does legal advice for social workers, sort of like LegalZoom. It prints out customized legal advice. It does Indian Child Welfare Act notices in a way that there's no other system out there that can. It also allows our attorneys and our social workers, because in LA County, we have 115 lawyers, some 8,000 or 9,000 social workers, and oddly enough, they don't always know who each other are. So our system has solved that problem by giving a link so that all the users know who they are. And we've reduced the costs to the county as a result of continuances of court hearings very significantly. In the multiples of millions of dollars has been our cost reduction, our cost avoidance. And it's been quite a journey and quite an experience. But one of the other things that we sort of wanted to talk about were some of the challenges that we face when it comes to data sharing and information sharing, and why we really need to get ahead of changing these laws. And I think about a case that I tried not that long ago. I know poor Jimmy's sick of hearing about this case because it was long and it was grueling, but it involved a family that the mothers and the fathers, 2 sets of families, mothers and fathers were both all related to each other. All 4 of them were within 2 degrees of kinship. The family had 2 deceased children. Lots of questions about why they died. One of them was sexually molested on the date of death. Lots of questions, complex medical issues, complex social issues, lots of information about this family all over the United States. What became very apparent about the challenges of everybody hiding in their silos was the sheriff's department had information they didn't want to give to the social worker, because if they gave it to the social worker would put it in a report, and if they put it in a report, then the parents would get it, and that would interfere with the law enforcement's investigation, and they wanted people to go to jail. Okay, I get it. But the problem is, what the social worker didn't know is that there was this great videotape of the parents during the arrest talking about what happened on the night of the second child's death. This is important stuff. The social worker needed that because it showed parents who were clearly under the influence. There was a lot of very rich social work related information there. I could get it, but the social worker couldn't. Didn't make a lot of sense because I couldn't do the analysis on it. The coroner's office needed to know what all the medications were, because there was a very large bucket of prescription pill bottles that law enforcement recovered. The coroner's office needed to know what those all were. But we couldn't get all that without releases of information from the parents, because the pharmacy wouldn't turn it over. And we couldn't get the releases of information from the parents because the law enforcement didn't want them to be tipped off to the fact that they were about to get arrested. So there was a bunch of people, but it's okay. The sheriff's department likewise didn't know that the social worker had uncovered a witness in Florida who had observed some of the sexual molestation. But the sheriff's department didn't know that because the social worker didn't think they could share the information back with the sheriff's department. So it became a massive headache to try to actually put a case together where everybody had all the information so that we could actually litigate the case and do it right. So it really highlighted for me the need to start breaking down these walls and for us to be sharing information in a really meaningful way so that we can do a better job for our clients.
I know we've got time constraints. I'd like to make one comment. Jim mentioned that we had designed a child welfare system that didn't communicate with the courts, and the court system didn't communicate with us. When we designed the child welfare case management system 20-some years ago, we absolutely... Pardon?
You intentionally did that.
Oh, absolutely. I mean, people talk about silos. We didn't have a silo. We had a fortress. We absolutely didn't want anybody to get in under any circumstances if they didn't work for a child welfare department. And for the first time ever, we've had meetings between OSI and social services, the leadership directors of both departments, and we are now procuring, or we're working on the new RFP for the new child welfare system. And for the first time, we are building in from the beginning interoperability. We're going to make the vendors aware that there needs to be sharing, or the ability to share, between not just the courts and the child welfare department, but ideally you're going to be able to have foster parents when a kid gets placed with them Friday at midnight, instead of showing up with a plastic bag of clothes and no health records, they're going to be able to go in on whatever replaces iPhones and find out the basic health information on the child, whether they've got asthma or diabetes or you know, they've got a peanut allergy. This is information that you need right away rather than a month later after an asthma attack already has occurred that the foster parent didn't deal with properly. So I believe it's the first system in California that has consciously focused on interoperability in its development. So that's a move in the right direction. So anyway, we're a couple minutes over only. Are there any questions? Or yes, Belinda.
In going through the committee meetings and the things that we were working on, and something that didn't occur to me just right now in this discussion is, I think it's great that we all figure out a way to share this kind of information, but the one thing that would worry me is we have to, and this is where I wonder whether even doing anything administratively works for this. How do we lock it down so that it can't get outside of the people who absolutely have to have that? In other words, a PRA request, a subpoena,
right,
you know, that kind of thing. I mean, it's critical information when you need it, but lots of people want it.
Yeah.
I think that there's even perhaps a more, you know, a bigger issue. I don't know that there's universal agreement as to who all should have access to it.
No, and there isn't, you know, and these are challenges that are going to make it more complex. It's a lot easier to build a system in the fortress mode. You know, if you're going to start letting people have access, you're going to have to put controls. You're going to have certain people get some information, but not everything. And then they're going to have, like, the foster parents that know the child's HIV status. They have to keep that confidential. So it's going to be more complex, but it's also going to, in the long run, better serve the needs of the clients. So, Daniel.
One of the things we talked about a lot was obviously the child welfare world, but the information sharing confidentiality touches everything else in HHS. And I want you to, if you could, just speak to some of the other areas, because I want to make sure that we're just not focused on child welfare.
Right.
In terms of education and health, mental health, those kinds of things as well.
Yeah, we've got, I mentioned earlier, we have an issue right now we're working on between the Department of Aging and Social Services that licenses the residential care facilities for the elderly, and Belinda at Public Health, who licenses the skilled nursing homes. It's not a children's issue, but it's one where the issue involves whether, when you've got a federal law that says when the ombudsman receives a complaint, they are not to, it's confidential and they can't release the information without the consent of the complainant. Well, what do you do when you're in the ombudsman's investigating a complaint, and while they're in the facility, they witness the licensee potentially harming not just the complainant, but perhaps other residents? You know, do you report that to the state licensing agency with oversight? I think we'd like to get to yes on that one, but the federal attorneys have been cautious in this area, and so we've got ongoing discussions now between Belinda and I think the aging, I think I saw, yes, here, and social services, yes. So we're going to have 3 different departments involved in that one, and we've already, even though we haven't formally implemented all of the new governance structure, we're in effect doing that now to try to get that kind of an issue.
So would that be an example of a particular situational challenge or problem that would be raised to the governance committee, and how do those things make their way out of that really bad cycle of just silliness and making changes to it?
If the 3 departments, the council can resolve it, then we'd prefer that happen at that level, and it be, you know, that they share the information and move on. If not, then it would be elevated to the new legal committee, which Gretchen referenced yesterday, who will examine it and make recommendations, and then ultimately, I forget what the top level executive governance committee in the agency would make the final decision. And you know, but ideally, we would like to get things resolved without. I found that often when you set up a governance oversight group, you often encourage people to not have to let things get to that point, that they have to go and be solved by somebody above them.
Well, I think that one of the things that we're trying to encourage here is for those kinds of questions to have a place to go to, as opposed to just getting sort of stuck in the bureaucracy or in a department. And you know, we've always done it that way. We can't. There's no clear way to move forward on addressing some of those things that could be addressed. And I'm hoping that when we're in our discussions later this afternoon, that those kinds of topics are clearly articulated by the people in this room. What are the kinds of things that we need to address? Will this structure allow us to do that?
And we don't want things to get stuck and not. I'm working on an issue with LA County where they elevated an issue a couple of years ago and to a state agency, and no answer ever came, and it's 2 years later. And so we're now reviving that issue, and we're going to try to use this structure to try to get a solution to it. So I think a lot of counties and folks have felt in the past, they raise issues, they never get a resolution, and they just give up and they stop asking. And what we're trying to do is create structures where we can be more responsive and get the problems resolved. So, yes.
Is there a place either on the website for interoperability, or a place that counties can go to look at, say, past resolutions of data sharing that you have solved, or
I
as
don't
New York
think there
said-
is now, but I think that should go on the list of things that I mean, I think out of this whole project there's a lot of stuff on Stewart's website, and I know OSI is going to be looking at what to put on the web, but I don't think that exists now, but it's a good idea.
So in a dream world, from a county perspective, because that's where I come from, when I have a data sharing issue with another agency or department within my county, I would love to be able to go to a place to see if another county has tackled that, their analysis on the law, and then some weigh in from the state, whether that's a good uniform interpretation, so that I can then go back to my clients and I can say, this is the way the state is saying, this is the low-hanging fruit that we don't need a consent, that we can move forward on.
It's a good idea, and I'm wondering if CocoNet, the county council, do they?
I'm just going to give a plug for CocoNet.
Yeah.
The County Councils Association basically has its interest, so you have to be like a county council to get on it. But they have a posting where, the attorneys can post, has anyone ever seen this kind of issue and this kind of problem? And we're really pretty responsive about answering those questions as best we can. And oftentimes you'll find that you're not unique, and some other county has dealt with the same issue and come up with a solution.
And I wonder within that site, it's broken down by practice group?
It
and
is
this
broken down by
crosses so many?
practice groups. The one I'm most interested in, of course, is child welfare, which deals with all our problems. But there's one for health services, and there's one for law enforcement, and I don't know
There's
them
one for
all.
public welfare, too.
There's one for public
Yeah.
welfare as well, yes.
We should start one for interoperability, because someone subscribed to child welfare wouldn't get health and welfare or probate or mental health, which this is what we're looking at here.
We should
And
talk
only get
offline
those-
about this. We're going to have an advisory committee of county councils and advocates to work with us on these issues. And I think whether it's in the CocoNet or wherever, having online access to that kind of thing makes a lot of sense.
Yeah, Larry, I just wanted to respond to Dan's point. What you've been talking about is what we're going to do at the state with CHHS, with our departments, but you have silos at the county levels, and some
yeah.
counties are doing very well working together within their silos, and then you have silos at the federal level, and we have had situations where we could work it out, but the federal silo said, no, you can't do what you want to do. And we've taken it up to the feds and lost. So we're working on this at all the different levels, Dan.